Hello and good morning and welcome to Gough Square Live. My name is Jonathan Goulding and I'm joined by Alison Hollis. Alison and I are both barristers at Gough Square Chambers, specialising in consumer and trading standards law. Today we're going to be talking about test purchases and surveillance. Both are important topics concerning investigatory powers possessed by local authorities. The aim of our talk today, which will last about 20 minutes, is to give a high-level overview of the main principles in relation to the legal framework applying to both areas. Some of you will be familiar with test purchases, having based a prosecution on one, often in the area of underage sales. Maybe in an investigation you have had to seek authorisation under the Regulatory and Investigatory Powers Act 2000, often known as REPA. We will be looking at the framework for each area. And as I have said, it will be a high-level talk because these areas get very technical very quickly. As in the last Gough Square Live, we won't be answering any questions live on air, and we will try to keep the whole talk under 20 minutes. Do still feel free to email us later if you have any questions. Now, test purchases. Test purchasing has been part of the enforcement toolkit of weights and measures officers for a very long time. It is an effective way to determine compliance by traders with a whole host of laws. It might be the purchase of food products to ascertain whether labelling obligations under food safety and hygiene regulations are being complied with, such as whether an item is being offered for sale within its use-by date. But perhaps the classic area for use of test purchasing is in the area of age-restricted sales, for example, alcohol, fireworks and cigarettes. All are subject to legislation which make it a criminal offence to sell to a person under 18 years of age. A test purchase involves the practice of covert techniques. The vendor does not know that the purchase is being made. Sometimes the enforcing authority will deploy a volunteer to carry out the purchase. Very often this is a child. Without such a volunteer, it is obviously not possible to test a trader's compliance with underage legislation. This has been a contentious area over the years, with traders making claims in court, unsuccessfully, that a sale induced in this way should be excluded from the evidence as entrapment. More of that later. Clearly, test purchase powers are far-reaching and necessarily involve a trader being made the subject of covert investigation on their own premises.
So, what's the legal authority for those far-ranging powers? How are children lawfully permitted to take part in them? Well, at common law, it's long been recognised that a degree of active involvement by the police, and by extension investigators such as trading standards officers, is generally regarded as acceptable. In the case of Loosely, which is referred to in slide 1, at paragraph 3, Lord Nichols said that test purchases fall easily into this category of acceptable active involvement. The rationale is that test purchases merely involve a trader being approached in his shop in the same way as any ordinary customer might have done. And as Lord Nichols went on to say, indeed conduct of this nature by officials is sometimes expressly authorised by an Act of Parliament. The statute creating an offence may authorise officials to make test purchases, as in section 27 of the Trade Descriptions Act 1968. So the power's always been there, and was sometimes given statutory force. However, matters have advanced in consumer rights legislation since Loosely, and we're now fortunate that we don't have to look any further than Schedule 5 to the Consumer Rights Act 2015 for the power of a local authority enforcer to make a test purchase. That codifies previous powers and repeals, for example, Section 27 of the Trade Descriptions Act mentioned by Lord Nichols.
The power to test purchase products is found in paragraph 21 of Schedule 5 to the Consumer Rights Act 2015, which provides as follows. An officer of an enforcer may make a purchase of a product or enter into an agreement to secure the provision of a product, and for the purposes of exercising that power, an officer may, at any reasonable time, enter premises to which the public has access, whether or not the public has access at that time, and inspect any product on the premises which the public may inspect. The power of entry in subparagraph 2 may be exercised without first giving notice or obtaining a warrant. So the power is akin to an officer acting the manner of a consumer, and the officer is not exercising a power of entry for which a notice or warrant requirement applies. Paragraph 21(1) of Schedule 5 expressly provides that an officer of the enforcer may make a purchase of a product or enter into an agreement to secure the provision of a product. That an officer should enter at a reasonable time, as set out in the paragraph, generally means when a business is open for trade.
So the question posed earlier, how are children authorised to undertake test purchases and what's the legal power for them to be used? Paragraph 7(1)(d) of Schedule 5 to the Consumer Rights Act 2015 provides that a volunteer or non-employee of a local authority, authorised by the authority to exercise the power of test purchasing under paragraph 21, is an officer for the purposes of the test purchase. This now gives statutory power for an enforcer to authorise a child volunteer. Once authorised, the child is deemed to be an officer and with the same powers under Schedule 5. Children have long been used in test purchases. Paragraph 7(1)(d), however, confirms beyond any doubt that a child can validly be authorised to undertake a test purchase on behalf of a local authority. And this really enshrines long-standing practice and confirms earlier case law rejecting challenges to the use of children in test purchases. In the case of Ealing London Borough Council and Woolworths plc, an 11-year-old boy had been used to purchase an 18 category video film at the respondent's shop. The video was duly sold. However, the justices in that case excluded the evidence for entrapment under Section 78 of PACE 1984 because the defendant had been induced to make the sale when otherwise no such sale would have taken place. But on appeal, the Divisional Court robustly overturned that decision, and it was clear that the child did not incite, aid, abet the commission of that offence. So by purchasing the video, he was simply playing a part in the situation, which rendered Woolworths culpable.
So that is a quick run through the test purchasing powers of local authorities. Just before we move on to surveillance, it is not likely in the vast majority of test purchases that the purchase results in the obtaining of private information or that the purchaser maintains a personal or other relationship with the seller and becomes a covert human intelligence source, or a CHIS as it is colloquially known, which requires Reaper authorization. If there are circumstances where Reaper authorization should be considered, it would hopefully be obvious and the authorizing officer would have to act accordingly. This leads us neatly into the second topic, surveillance.
Yes, that's right, John. Surveillance and the law in relation to it is quite complicated. Today we're going to give a brief overview of powers that are available to local authorities. The starting point, of course, is Reaper, which John's already referred to, and that relates to intelligence gathering activity and provides a framework for authorising surveillance. This has in turn been amended and supplemented by the Protection of Freedoms Act 2012, and that's reduced the scope of activity which is capable of being authorised under Reaper for use by local authorities. Reaper distinguishes between three types of intelligence gathering activity. One is intrusive surveillance, the second is directed surveillance, and the third is the use of covert human intelligence source, or a CHIS. We shall take a look at each type and its application to local authorities. If I look first at intrusive surveillance. Intrusive surveillance is defined in section 26(3) of Reaper as covert surveillance that is carried out in relation to anything taking place on any residential premises or in any private vehicle, and involves the presence of an individual on the premises or in the vehicle, or is carried out by the means of a surveillance device. Intrusive surveillance may not be authorised by a local authority. The second type is directed surveillance, and that's defined in section 26(2). Surveillance is directed if it is covert but not intrusive, and is undertaken for the purpose of a specific investigation or a specific operation, and in such a manner as is likely to result in the obtaining of private information about a person, whether or not one specifically identified for the purposes of the investigation or operation, and otherwise than by way of an immediate response to events or circumstances, the nature of which is such that it wouldn't be reasonably practicable for an authorisation under this part to be sought for the carrying out of surveillance. An example of directed surveillance could be, in the context of a planned operation or investigation, listening to or recording a conversation held between two people in a public place, for example in the street or on a bus. And the third type is a covert human intelligence source, or a CHIS, and a CHIS is defined in section 26.8 of RIPA. A person is a CHIS if he establishes or maintains a personal or other relationship with a person for the covert purpose facilitating the doing of anything falling within paragraph B or C. Paragraph B says that he is a CHIS if he covertly uses such a relationship to obtain information or to provide access to any information to another person. Or C says he covertly discloses information obtained by the use of such a relationship or as a consequence of the existence of such a relationship. An example of that could be a corner shop owner selling illicit tobacco, but only to people who he knows and has grown to trust. In order to carry out a test purchase, there must therefore be a relationship between the test purchaser and the suspect. A CHIS would be required to establish and use that relationship for the purpose of the test purchase. Only directed surveillance and covert surveillance can be authorised by a local authority. There are certain prerequisites in the authorising of both of these.
Authorisation by the local authority. In most cases, a DSA or use of a CHIS may be authorised by a director, head of service or a service manager within a local authority. Where directed surveillance or use of a CHIS is likely to obtain confidential information, or the use of a juvenile or vulnerable person as a CHIS, the required authorisation must be by a head of paid service. The required authorising officers are to be found in the schedules to RIPA. As stated earlier, in both the case of directed surveillance and the use of a CHIS, a local authority will also require judicial approval before the authorisation will be granted. To that end, the Home Office has issued guidance on the procedure for judicial approval of DSAs and CHIS authorisation. It is worth noting in summary that for judicial approval, 6 conditions should be met. 1. An officer will have to attend. It is likely to be the investigating officer who will answer any questions of the Justices of the Peace. 2. The hearing will be in private, but the officer will still have to be sworn and present evidence as required. 3. There are forms and supporting papers to make the case. It is not sufficient to provide oral evidence where it is not reflected or supported in the papers provided. 4. The Justice of the Peace must be satisfied there are reasonable grounds to believe the authorisation was necessary and proportionate. 5. The Justice of the Peace must consider whether there continue to be reasonable grounds. And 6. The Justice of the Peace must be satisfied the person who granted the authorisation is an appropriate designated person within the local authority. Further, they must be satisfied that it was made with any applicable legal restrictions. For example, that the crime threshold for directed surveillance is met. Finally, a word on non-authorised surveillance. Generally speaking, surveillance which is not intrusive and does not amount to directed surveillance or use of a CHIS does not require authorisation under RIPA. Examples are overt use of CCTV and ANPR. So, we've given an overview of the powers available to a local authority under RIPA. Clearly, it is very important to consider the framework under RIPA very carefully and ensure the correct authorisations are obtained. Well, that is all from us today. Thank you very much for logging in. Hopefully we have provided you with a useful overview of local authority test purchase and surveillance powers. As we said at the beginning, please do email with any questions you might have. And finally, please tune in to our next instalment of Gough Square Live, which will be on the 4th of July at 11 o'clock in the morning, when Cameron Crowe and Sabrina Goodchild will be speaking about prosecuting fraud. Goodbye.
Goodbye.